It's very interesting that many employees feel that sexual harassment must occur at work, and the definition of being at work is a very narrow definition for most employees. However, courts have found that the location of the harassment can expand past the work location. For example, if the employer has a company-sponsored party, or there's business travel, or even dinner, sexual harassment can occur off-site. And that's something that a lot of employees do not know, and actually a lot of employers do not know as well. And that is something that we need to emphasize in terms of the location of the harassment and sexual harassment in general. Now, I emphasize this many times throughout the lecture because we need to make sure that people understand the victim of sexual harassment does not necessarily need to be the target. And this is what many people accused of sexual harassment also do not understand. And that is that a victim of sexual harassment can also be a person that has perceived harassment, but not necessarily have been the target of the harassment itself. So if you're an employer and someone comes up to you and says, hey, I've been watching, Sarah go up to George for a week, and, she's just flirting with him every day. It's starting to, bother me a little bit. Sarah's got to control herself. She's bothering me. The employer typically will say, well, did Sarah talk to you? And you would say, well, the accusing individual would say, well, no, Sarah didn't come up to me. And the employer would just brush it off. So we want to avoid that type of situation that occurs. As a general rule, sexual harassment, any type of sexual harassment is not going to be permitted. It is very broad in scope, and it is very broad in definition, and we want to make sure employers are not caught in this type of environment where they are accused of sexual harassment but they didn't think that they did it. Now, Emery, what do you think when an employer is accused of sexual harassment or someone complains? Many times they don't call their attorney, right? Many times they don't even have an attorney. Sometimes they don't even have HR. What are your recommendations when an employer calls you? Obviously, because KCAL has a lot of services, and they say, hey, somebody at my office has said something, and it makes me a little bit uncomfortable. I don't know what to do. What has kind of been your general guideline on how to deal with issues like this?
Funny thing you mentioned, we do get these calls quite a bit. A lot of times, an employer will call us and say, hey, I have this incident where someone left the company, came back and said I was wrongfully discharged, I was harassed by so-and-so, what can I do? I have all the insurance purchased, I have business insurance in place, I have workers' comp in place, everything in place. Does any of these insurance covered? I would like to stress that workers' comp do not cover these cases. So first thing is I look at their file to see if they have a EPLI insurance policy in place. If they don't have an EPLI policy in place, then I would suggest them to obtain a policy. Of course, the insurance company do ask on the application if you have any current pending existing claims that could possibly affect the quote. The application do ask if you have any prior claim, current claim, any future claims. If you want to get a quote, the application do ask then your nature of business, your type of industry, how many employees you have, what is the turnover rate. The reason they ask about this is because certain industries do pose a higher risk, and also the number of employees as well. If you're interested in obtaining this insurance, why is the number of employees so important? The number of employees so important is because the more employees you have, the more exposure you can actually having the sexual harassment. Because there's more people you have to overlook. You can have to have a management that overlook who's doing what correctly or not. And we also want you to have an HR, a designated HR person. The hiring and firing procedure is also very important because we don't want you to just hire anybody or fire anybody without even consulting with their HR. Or you have your HR properly trained to have the sexual harassment seminar trained. Also, the insurance company application will also ask you if you have a employee handbook. Before, if you want to get a quote, you just complete an application. We just give you a quote. But now, even providing a quote, the insurance company wants to see the employee handbook. And if you don't have it on hand, if you want to bind the policy later on, of course, you can always submit that later on. Of course, you don't have the handbook on hand. You can actually contact Paul to actually draft the handbook. But again, a lot of times when you contact us for these type of matters, we first of all look into if you have that insurance in place. If you don't have an EPLI insurance in place, we're more than welcome to give you a quote. And all you have to do is complete application, submit the handbook, and then the applications, it's a lot of yes, no questions. So don't be discouraged in completing the application at all.
You know, one of the questions that people may have is about what they need to disclose. Obviously, many times people get EPLI because they are worried about being sued. But is that a potential claim that needs to be brought to the insurance company's attention? I mean, if that's the case, you know, I have 40 employees. Do I say that I think all 40 employees are going to sue me? I mean, what is the fine line in which, I need to state to you, Emery, that, I have a potential claim?
We really want to be upfront and honest with the insurance company, because if you do have a potential claim right now and on the application you say no, later on and the claims comes in and it was prior to submitting the application or prior to the policy being enforced, then the insurance company can say, hey, we're not going to pick up the claim. The reason is because the EPLI insurance policy is actually a claims-made form. Here, this is what I wanted to actually explain the difference between what is claims-made and occurrence form. There's two types of policies. You're going to see a lot of your business owner's policy being on an occurrence form. Occurrence form is basically whenever the claim occurred, whenever you report it, the insurance policy will pick up that claim, regardless when it occurred, when you report it. Now, what claims made is it occurred and reported date should be when the policy is actually enforced. Therefore, if your policy was enforced in May and then something occurred in March and you come back and then reported it, it's not going to be covered. It has to occur during the policy term when the policy is actually enforced, which is kind of difficult. Why? Is because the insurance company don't want to give you the occurrence form, so it's actually very, very broad, because anytime something of this matter occurs, the insurance company will have to pick up the claim. So they're actually taking on a high risk. So that's why they will only offer claims made. It's actually something that you need to remember.
Well, I think that's a great point in terms of the claims made, is that this is a little bit different than the other types of insurances that we typically purchase or that we're comfortable with purchasing. I can be able to say from a legal standpoint that if an attorney has already made a demand, a written demand on you, that is definitely a signal to you that when you apply for EPLI, you should disclose that. A lot of clients that have come to me, and also KCAL as well, believe that if there's been a written demand by an attorney, that's not considered a potential claim because of the fact that the lawsuit has not been filed. And I would disagree with that. Now, if you have a dispute with your employee, for example, your employee got mad, yeah, that's a little bit more difficult, and that's a personal decision. But in my opinion, the fine line is drawn when an employee's attorney or an attorney in general makes a claim on you by basically writing to you and saying that your employee is unhappy. That is definitely something that you should disclose. That is definitely something that we want to avoid, because I think Emory is very smart in the sense that, purchasing insurance is one issue, but having purchasing insurance and having the claim denied is a totally different issue, and it's very grueling and difficult to accept. How can I purchase insurance and have it denied? Well, one of the ways that insurances are routinely denied is that the applicant at the time didn't write out correctly, really just was not transparent with the insurance company. The insurance company would say, well, if we knew about the claim, we would not have opened a policy with them. So this is something to consider and something that you need to worry about when you are purchasing insurance. And I'm very sure that when you come to KCAL, that they'll explain that more fully. Let's talk about the second type of harassment, and that is quid pro quo. This is much easier. As you remember, there are two types of sexual harassment. This will be your second type. This is the type that is much easier to understand. Most people, I believe, are more comfortable with this area. Essentially, it is the receipt or denial of an employment benefit, and it's dependent on the victim submitting or succumbing to the harasser's advances, offers, or demands, which are often sexual in nature. Often, not always. So it doesn't necessarily need to be sexual in nature. So again, it's the receipt or denial of an employment benefit, and it's also dependent on the victim submitting or succumbing to the harasser's advances, offers, or demands, which are often sexual in nature. I previously talked about elements, and you have to remember the law is made up of elements. Without facts, there really is no law. So the elements of a quid pro quo sexual harassment claim is: 1, the respondent subjected the complainant to unwelcome sexual advances, requests for sexual favors, or other verbal, visual, or physical conduct of a sexual nature when submission to the conduct was made either explicitly or implicitly a term or condition of the complainant's employment or provision of services, or the submission to or rejection of the conduct by the complainant was used as the basis for employment decisions affecting the complainant. So let's give an example of what is a quid pro quo sexual harassment. Easy one. You need to have sex with me to get a raise. That's very easy. Second one is not so easy. I get to stare at your chest on a daily basis, and in so doing, you get to keep your job. Or, dressing sexy is part of, essentially the work requirement. And obviously, it's got to be unwelcome by you. Another one that, a typical example that I see that people don't really think about is in terms of the submission or rejection of the conduct was used as the basis for employment decisions, is essentially, in terms of rejecting sexual harassment. So sexual harassment doesn't necessarily need to be received. So some people believe that the victim actually physically needs to have received the sexual harassment, needs to have occurred for it to be sexual harassment. That's incorrect. Sexual harassment can also occur when there is a rejection of sexual advances. There is an actual rejection. Boss, I'm uncomfortable with going out to dinner with you, and next thing you know, the person's demoted. Boss, please stop looking at my chest. Next thing you know, the person's fired. Boss, stop looking at my legs. Something else occurs. So it doesn't necessarily need to actually be a receipt. It could also be a rejection of a potential sexual harassment issue. Now, what is the second element? The second element you've already heard before. It's very easy. The analysis is, was the harasser a manager, supervisor, or agent of the employer, or the employer or employer's agents or supervisors knew or should have known of the harassing conduct and failed to take immediate and appropriate corrective action? So what is that? If the harasser is a manager, both the harasser, who is a manager, as well as the corporation is liable. If the harasser is a lower level, non-managerial employee, then the employer knew or should have known of the harassing conduct for the employer to be liable. So there are situations where only the harasser is liable, but not the employer. So this is very important. The harasser will always be liable when there is sexual harassment. The employer may be liable when there is sexual harassment. When the harasser is a manager, the employer is also liable. When the harasser is a non-manager, the employer may be liable. So here are some examples of quid pro quo sexual harassment. An offer of employment benefit in exchange for sexual favors, or actual or threatened reprisal after a negative response to sexual advances. So we've given some examples earlier of that. So many employers don't realize that you can be liable for sexual harassment even though no sexual harassment has occurred. You know, there have been cases out there where an employer has actually violated the law, although the employee made up the sexual harassment. The employee lied. Why? Because employers are required to take all reasonable steps to prevent harassment from occurring, such as having a harassment policy and training employees on sexual harassment, such as what you're listening to today. Why is that important? Because if an employer does not take seriously the allegations of an employee, they're still violating the law, even when the employee has made up the accusation of sexual harassment. Now, this is a gray area of law, but I'm very firm. My personal belief is if you are an employer and someone comes to you and alleges sexual harassment, you have to take it seriously, particularly if you believe this employee is fabricating his or her story. Because if you refuse to do so, then there is potentially a violation in that you did not take reasonable steps to prevent harassment. So, are there any defenses to harassment under FEHA? The answer is no, there are no defenses. There is no viable affirmative defense applicable to sexual harassment cases, since there is no legal justification for acts of workplace harassment. So what's an affirmative defense? So a defense basically is someone sues you as an employer, you said, I didn't sexually harass. An affirmative defense means even if I did do all the things that you claim, I still win. So let me give you an example. I hire somebody to go kill somebody for $100,000. I enter into a contract. I pay the other person $100,000. The person decides not to do it, and I decide to sue. I can be able to prove there was an agreement, I gave the money, there was breach, and I was damaged. What's the affirmative defense? The affirmative defense basically is, although everything that Paul says is correct, an illegal contract to go out and kill somebody is improper, and therefore Paul loses. That's what an affirmative defense is. In cases of sexual harassment, there is no justification and ability for there to be an affirmative defense to win a lawsuit. So, Emery, I'm just going to ask a very frank question. Have you seen any of your clients that didn't get essentially the insurance and had to go through the entire sexual harassment process? And, you know, obviously without naming names, have you seen any of the judgments or any of the consequences of a sexual harassment claim?
I have, not as frequent as I think, but a lot of times, because we deal with a lot of Asian companies where a lot of times they just sweep it under the rug and they don't bring it up. But yes, there were cases where they actually came across something like that. And unfortunately, those particular customers didn't have any EPLI insurance in place. So of course, they need to assign an attorney to represent and defend. And of course, they can just settle this. I don't know what the settlement was, but they pretty much settled it. Again, I wanted to stress out that the EPLI insurance doesn't only cover the sexual harassment lawsuits. It also covers the wrongful terminations, not hiring or not hiring someone because of their race. Or like firing someone for no particular reason. So it's not just for sexual harassment. So that insurance is actually very broad. Again, just because someone doesn't speak of it doesn't mean it doesn't occur. So yes, from time to time we do come across cases like that from our customers.
Yeah, I can be able to tell you that, one of the things, and I've talked about attorney fees before, but under the most ideal situation, this is without any type of insurance. On defense side, you're probably going to be looking, when I say ideal situation, I mean the attorney's actually litigating and working. Obviously, if you tell the attorney just lay down and die and wait till trial and just only react but don't be proactive, you can get attorney fees probably around $55,000 over the life of a lawsuit. But frankly speaking, you will be looking at a six-figure attorney fees billed to you over the life of a lawsuit in terms of a sexual harassment lawsuit. And I can say that typically on plaintiff side, when I have seen essentially a memorandum of costs and attorney fees to go out to the court, it's around $250,000. So under the FEHA, what happens is, if there is, on any type of labor claim, discrimination, sexual harassment, even wage and hour, where there's overtime, missed meal breaks, missed rest breaks, essentially you have to pay for the other side's attorney fees and costs if you lose. The other side doesn't have to pay for your attorney fees and costs if you lose, if they lose. So it's a one-sided attorney fee provision. It is unfair, unfortunately. A majority of these cases settle for a reason, and that is that unless the employer takes a position, there's one of two things. One, we are absolutely going to win, and I do not care about the amount of attorney fees. Or two, we are going to take a position that if we don't defend this case, then we're going to have other sexual harassment lawsuits as well. Otherwise, typically these type of cases settle, if anything, due to the amount of attorney fees needed on defense, because sexual harassment is a very serious allegation, and there are a lot of penalties associated with it, which are called remedies. So in a lawsuit, there are two legs. If you imagine kind of a human being with two legs, and on the left side is liability. And once you prove liability, then you got to talk about remedies, and remedies are what do you get if you prove liability. Most clients that are plaintiff and defense focus on the other leg, meaning the leg in terms of the remedies. But really you should be focused more on the liability first before we talk about remedies. Everything prior to this time has been about liability. Now let's talk about the leg that everybody's interested about. What do you get? The first thing you get on plaintiff side is you are made what's called made whole. So the goal of a lawsuit is to make whole the victim. You get back pay, front pay, reinstatement, transfer, purging of your personnel file. So what is back pay? Back pay is all the amount of money the victim would have received but for the sexual harassment up until termination and or the time of trial. So for example, let's say that a person is a victim of sexual harassment and she was demoted. She didn't want to have sex with her employer, so she was demoted. All that time, the money that she could have received, you need to give back over to her. That includes while she was working, after she left the company, up until the time of judgment. What is front pay? Front pay is the reasonable amount of time this employee would have stayed at the company. 1 year, 2 years, 20 years, 40 years. That's front pay. What is reinstatement? Where the employer needs to reinstate the employee back to his or her original position. Transfer to a different department, and even purging of the personnel file. So this is not a new area of law, but I find more attorneys on plaintiff side are interested in it. And that is When an employer gets upset at an employee, they decide to trash them and destroy them on paper, so that when the employee file goes to a new employer, the new employer won't hire them. Well, everybody knows of defamation. And defamation basically is where you wrongfully state something is true that affects somebody else. That's kind of a general scheme of what defamation is. The purging of the personnel file is part of the defamation in employment. And although we are not talking about the defamation of employment in this context, I do want to warn a lot of employers that messing around with a former employee's personnel file can be actionable in court, and it is very serious. So one of the remedies is purging of the personnel files where it's actually sealed and destroyed. You can also get compensatory damages for emotional and physical distress. And the great thing on plaintiff side, not so great thing in defense side, is that it's unlimited in state civil courts, although it is capped in the administrative Fair Employment and Housing Commission. And you also get punitive damages, which is very, a lot of attorneys on plaintiff side love it, defense side hate it. You know, it's kind of funny when you, particularly if you're Asian, it's kind of funny. You get off the airplane, your 2 feet touch the ground, and there are two things you know about. The U.S. is the best place to live in the entire world, and the McDonald's hot coffee cup case. So it's kind of weird. It's, you know, you arrive and you love the weather, you love the people, and you immediately find out about this McDonald's hot coffee cup. And what happened with this during the 80s is that this lady, she got burned due to McDonald's hot coffee, and her burns were severe. But what was more severe? The punitive damages, millions and millions of dollars that were given over to this lady in the McDonald's hot coffee cup case. That millions and millions of dollars, that was the punitive damages. So you have the damages, and then you have punitive damages, which are on top of the regular damages that occur in sexual harassment. You also get affirmative relief, where the employer may be required to implement workplace policies, conduct training. You have injunctive relief, and like I previously spoke on, attorney fees and costs. You know, one time I remember, I was a lot younger back then, and I was approached with a case. It was post-judgment. A client had already lost in court. It was based on essentially a labor case, and the attorney fees was $500,000, and the damages were less than $75,000. And I was like, oh, you know, I was a young attorney. I said, don't worry about it. I can handle it. Everything will be fine. And obviously the client was like, I hated my previous attorney. He did a horrible job. I shouldn't have lost. Well, the point that I'm trying to make is I went into court, and the $500,000 got reduced to about $300,000. And I told the judge, Your Honor, I think you need to give a more reasonable number. And the judge was furious. The judge was absolutely furious and said if I did not take what she had recommended, that she was going to issue the full award. The reason why I say that is because for $75,000, around $75,000, essentially they had to pay $300,000 in attorney fees. But I think what she had suggested is something that we all need to learn. Attorney fees and costs are attributable to the losing employer, all right, to the losing party that is the employer. And again, it's one-sided, meaning that if the employee loses, they don't have to pay any penalties. But if you lose, the employer loses, or the harasser loses, there are some significant penalties, particularly with attorney fees. Now, some people consider that unfair, but actually the California Supreme Court, as well as many other cases, have said, without the one-sided attorney fees provision, no good attorney would ever take a case on. So if, for example, there were not attorney fees, why would any attorney ever fight for somebody for $25,000 or $30,000? Why would somebody ever help anybody that's poor? Well, the reason why they do that is they want to hit big fish like you, and they want to get the attorney fees. They're not worried about the damages. $25,000, $30,000, $50,000, $100,000, that doesn't mean anything to the plaintiff side attorney. What they're really looking for is the attorney fees and costs. So it's something for you to think about. So there are some pretty significant differences between the state sexual harassment policies and law versus the federal. And the big differences are that the state prohibits harassment as well as discrimination. The FEHA extends protection to independent contractors as well. This is very different from federal. So sometimes an employer feels that I did not sexually harass this person because this person only came in to deliver something, like the UPS driver. How can I sexually harass the UPS driver when the UPS driver does not work for me? How can I sexually harass the FedEx delivery person? Well, in California, you can. And that's very different from other states. Also, under the state, an employer is strictly liable for the harassment of an employee that's an agent or supervisor, whether or not the employer knew about the harassing conduct. This is very different than other states. In other states, the employer is liable only if they knew. But in California, it doesn't matter. If you're a supervisor, not only are you liable, but your employer is liable. It's very different. Now, under Title VII, an employer has an affirmative defense to a charge of sexual harassment if the employer can show that it exercised reasonable care to prevent and correct promptly any sexual harassing behavior, and the employee reasonably failed to take advantage of any preventative or corrective opportunities provided by the employer to avoid harm. So under Title VII, it gives you more opportunities as an employer to escape. Unfortunately, you're in California. The FEHA bans harassment, and it extends to all employers. All employers. So this is very important, right? Because the other forms of discrimination only apply to employers that have over 5 employees. So essentially, if I hire one person, just one person, although I can discriminate against them, I can't be sued if I decide to, for example, racially discriminate against that person. However, for sexual harassment, all I have to do is have one employee. All I have to do is have one independent contractor, and I can still be sued. Very different. Many, many, many employers get caught on this small but important area of law. So, Emery, when an employee has, because you deal with a lot of people, what are some recommendations that you would give to employers and employees when they feel that there is sexual harassment in the workplace? Let's talk about employees. Although that this lecture is directed at management side, but what ends up happening if you are a management side employee and you feel you've been sexually harassed? Are there any recommendations that you can be able to give when you feel there has been sexual harassment at the workplace?
I think the management should, of course, first of all, take the sexual harassment training, the 2-hour training, which is very important. I think it's training and also talking to the employer about it. If you're the manager and either you are aware of any sexual harassment going on, or if you are personally being sexual harassed by someone, again, like Paul said, it could be direct or indirect for all we know. If it's indirect, just bring it up to the employer. Have the company know about it. So it's more of the communication and also the training. So always have your management train the course. It's very important, and this is actually very, very helpful to anyone that is actually manage a company or any department for that matter.
Yeah, I definitely would say that communication is so crucial. And that is one thing that employers don't do well, is they hear the words discrimination, harassment, sexual harassment, and they shut down. They get very scared. And instead of dealing with it head on, they, just like Emery had said, I think it was so apropos, that you sweep it under the rug and you basically say that it never existed. That is the worst thing that you can do. Because most employees that I've spoken to have always said this: I did not want to sue. They always say that. I didn't want to sue. But nobody listened to me. Nobody took the time to hear my needs. And in California, as an employer, you must hear their needs. So I think Emery is absolutely correct that the communication between departments, between managers, between the owner of a business and all of his or her employees is crucial to preventing a sexual harassment case. Now, one of the things that we want to say is that as a sexual harassment case is initiated, you will never be retaliated against. We want you to know that from the standpoint of the employer as well as your company, you not only have an open door, but you will not be discriminated against, and we will make sure that we conduct an effective investigation as it relates to every issue related to the complainant. Now, people have frequently asked, what do we do? You've said the things that kind of make sense. Everybody's going to say the same thing. You got to communicate, you got to write down, you can't discriminate, can't retaliate. But what do you do? Well, one of the ways that I think employers really fail on, I've said this before, is the failure of investigation, the failure to conduct a reasonable investigation. What some employers have begun doing is hiring third-party qualified neutral operators to give them a decision so that the employer can be able to say, this decision did not come from me. It came from somebody else. And that's what people have been doing. Some people have been hiring HR specialists. Some people have been hiring law firms. Some people have hired my law firm to give a legal opinion. But my recommendation has always been to suspend the harasser, suspend the alleged harasser until there's been a complete investigation. You can pay them, right? Now, I understand it's a little bit difficult. Some of the businesses out there, it is very difficult to have your manager suspended. But the last thing that you want is for the victim or the alleged victim to be fearful of the situation. Another way to do it is to make sure that the harasser and the victim aren't on the same schedule, or the harasser is moved to a different department. One of the things that we want to make sure is that we don't accidentally discriminate or retaliate against the person that is a victim of sexual harassment by essentially doing what many companies do. HR calls both of you in and says, hey, Sarah, I just want you to know that George said that you've been staring at his pants for the last 2 months. What do you say about that? I think that's a bad move for most HRs. And the management side, I really want to discourage you from doing that because it really shuts down the communication that Emery was talking about, really shuts down the goal of transparency in sexual harassment. So again, that's one of the reasons why there have been a move by many HRs to hire third-party neutrals to deal with the complaining employee. Also, what you have to do is you have to interview. You have to interview possible witnesses. And you have to be willing as a company to come down and to be able to make decisions and admonish all involved not to interfere with the investigation or attempt to sway any witnesses. And you need to make credibility determinations. The best case on plaintiff's side is when there's an allegation of sexual harassment and there's no documentation at all. Zero. Nothing. And then the employer says, yeah, I did a really good job. The difficult cases of sexual harassment is when the employer undertakes not only a sophisticated but an intelligent investigation so that it can come to a conclusion that yes, there is, or yes, there is not sexual harassment. And another thing that I recommend you doing is involving the complaining employee. There's nothing wrong with allowing the complaining employee to make her statement known. Because let me tell you what may happen. If you tell the complaining employee to write down everything that occurred, you're really scared she's going to write down 100 pages. He or she's going to write down 100 pages. But you'll really find it's probably going to be less than 1 page long. And what's going to end up happening is that if this employee ends up suing the company, they're going to make up a lot more things, particularly after they hired an attorney. Well, what are you going to do? You're going to take out that one piece of paper and you're going to say, hey, you didn't say that before. When did you decide to make this up? Was it before or was it now? Somebody's lying. Eventually, you're going to draw a conclusion after the investigation as to whether or not the complaint was meritorious. And you're going to take appropriate corrective action. And you're going to provide the remedy to the complaining employee. Because again, most employees that are complaining, they just want to be heard. And once they are heard, and the employer really conducts an investigation and makes a determination, most employees are going to be okay with it. You know, it seems like the belief is every employee that claims sexual harassment just wants somebody to be fired. That's not true. I totally disagree with that. They just want to work in a regular environment. It doesn't matter whether the person that's harassing them is there or not. They just want to be normal. They just want to be happy. So if you've conducted a reasonable investigation and you've gone up to the person that's complaining and said, hey, you know, I want you to know we've conducted an investigation. We suspended him, suspended the person accused of sexual harassment, and we've come to the conclusion that there really wasn't anything there. I think that the complaining employee, as much as she may not agree, I don't necessarily think that that means that what the employer has done is illegal. What the employer typically does is they don't suspend anybody. They don't do any investigation. They just look at the complaining person and say, you know what? I can't wait to fire you. Can't wait to let you go. That's what most employers do. And that's the reason why employers are sued. And obviously, you're going to continue monitoring the workplace for compliance with workplace policy. What do you do if you still have questions? What do you do? Speak with your HR immediately, because the HR and the employer want to hear from you. What about if you don't have HR? What about if you don't have a policy in regard to sexual harassment? If you are a manager at a business, remember I've said this to you, sexual harassment involves you. Because what ultimately will happen is that if you are middle management and you have not taken the initiative to enact a sexual harassment policy, you most likely will be sued. Explain that to your new employer. Explain to your new employer how you as a manager did not protect the company that you previously worked for and you got sued. That is the reason why I think the sexual harassment policy and the sexual harassment lecture is so crucial and relevant to all of us here. Emery, did you have any other thoughts, any concluding thoughts that you have in regard to sexual harassment at all?
Just as a reminder, make sure that your HR, your management do take this training. It's actually very, very helpful. Communication is actually very important. Look into your company to see if you have a EPLI insurance in place. If you don't, feel free to contact me or our company. Anyone here can actually assist you in obtaining a quote. Remember, the application is not that long. It's only about 3 pages. We do ask that please answer the questions honestly, and also check with their HR to see if you have a employee handbook in place. If not, contact Paul to have that arranged. So yeah, this is actually a good reminder to everyone that training, communication, and get insurance policy in place if you don't have one.
Well, I wanted to, again, thank you, Emery. And in terms of your telephone number that people can contact you, do you mind giving that number again, please?
Yes, our general number here is 626-333-1111. This is our general number. But of course, you can always ask for me if you wish to speak to me.
And as previously said, I would definitely recommend that you speak to Emery. She's specialized in this area of law. Do you have a specific extension at all, or did they just ask for you?
I do have a direct line if you wish to reach me directly. My direct line is 626-369-8801 is my direct line.
And my telephone number is area code 626-356-8880, 626-356-8880. If you have any questions, I wanted to thank all of you today for just taking the time to listen to the both of us. On behalf of KCal Insurance, Emery, and myself, Paul Cheng, I wanted to thank all of you and good luck to you, because your success is the company's success. And so we definitely want to make sure that litigation is put at a minimum. Thank you.